Good afternoon and welcome to the Zaparas Lawyers Workers' Compensation Queensland webinar. Today I'm going to talk about understanding a worker's right to workers' compensation in Queensland. So first off, what is workers' compensation? Well, in Queensland, all employers must have workers' compensation insurance for all employees. And usually in Queensland, the most common form is WorkCover. Although a number of large employers, such as Woolworths, Coles, are self-insured, but all employers are covered by the same workers' compensation legislation. WorkCover is set up to provide financial help to those who get injured at work. The good news is it's a no-fault scheme, so in order to be entitled to workers' compensation, you have to be able to show that you were a worker and that work was a significant contributing factor to the injury. So what types of workers' compensation claims are there? Well, the first type of claim is what's known as a statutory claim. That's a no-fault based scheme. And as I've said, workers are entitled to benefits for being unable to work and for assistance with medical expenses whilst off work. So WorkCover will provide weekly wage replacement, and WorkCover are responsible for paying for necessary and reasonable medical treatment to try and get the injured worker back to work. Now, as well as statutory claims, there exists what are known as common law claims. Now, this is a fault-based scheme which takes place after the statutory claims process has ceased. So where we're able to show that an employer has been negligent, in other words, has failed in their duty of care to provide the worker with a safe place of work, a worker has a right to pursue what is known as a common law claim for compensation against the employer. WorkCover then become the insurance company of that employer, and the purpose of pursuing a common law claim is to recover compensation for pain and suffering, lost wages, medical expenses, and further wages and medical expenses. In order to pursue a common law claim, you will require legal representation, as this is a complex area of law. So who can make a workers' compensation claim? Well, any worker based in Queensland, but it also covers workers who may be injured in another state in Australia, but where the worker's employer's principal place of business is in Queensland. If you have any doubt as to which workers' compensation scheme applies, then you should first apply to the workers' compensation scheme where you're normally based. So what can be claimed for? Well, you can claim for a physical injury, which also includes an aggravation of a previous injury. A lot of people are under the mistaken belief that because they may have injured their back some years ago, they're unable to claim for a back injury if that's occurred at work now. But that's not the case. You can apply for an aggravation injury. WorkCover also includes psychological injuries, occupational diseases such as asbestosis, silicosis. Workers' compensation also covers industrial deafness. And in some tragic circumstances, if a family member has been killed as a result of a work accident, then members of the family can lodge what are known as a dependency claim. So what is an injury? In order to be capable of recovering workers' compensation benefits, you need to establish that work was a significant contributing factor to the injury. So that covers physical injuries, psychological injuries, diseases, and as I've stated, an aggravation of a pre-existing condition. In relation to claims for pure psychological injury, it is necessary to prove not only that the injury was caused at work, but there is an additional hurdle that an injured worker must overcome, and that is showing that the injury did not occur as a result of what is known as reasonable management action. There is an exclusion in the legislation for psychological injuries where if the injury arises out of management action, which usually comprises of performance management, discipline, transferring a worker, then unfortunately that injury will not be accepted. If you're in any doubt as to whether or not a psychological injury should be accepted by WorkCover, we urge you to seek legal advice. So what type of injuries do we see as a personal injury law firm? Well, predominantly in my area of practice, I see a lot of back injuries. Manual handling consists of by far the largest number of injuries that occur at work due to heavy lifting, strains, etc. But we also deal with fractures, whether it be to the arms, legs. As I've said before, psychological injuries are on the rise due to increased demands at work and unfortunate cases of bullying and harassment. Neck and head injuries, repetitive strain injuries, all these can occur in the workplace. And if those injuries cause the worker to be off work and require medical treatment, then the person should make an application for work cover. So what is considered out of or in the course of employment? Well, as well as the usual injuries doing the worker's normal job, work cover also covers injuries that occur whilst traveling to and from the workplace, or if you have a job that involves you attending conferences, training functions, etc., then that's also covered by work cover. Authorized coffee or lunch breaks is still considered to be in the course of employment. So if you happen to be injured in those sets of circumstances, you should still be able to claim workers' benefits. So what entitlements are available? Well, if you're unable to work because of injury, then work cover will cover your wages, not your full wages in normal circumstances, only a percentage. Work cover, as stated, are responsible for paying for reasonable and necessary medical treatment. And at the end of the work cover process, if the injured worker is left with a permanent impairment, then they are able to receive a lump sum payout for that injury. Now, in relation to weekly payments, work cover will normally cover up to 95% of the pre-injury wage for the first 13 weeks, and that percentage will drop to about 80% for the next 14 to 52 weeks. To continue to receive weekly benefits, it's a requirement of the work cover legislation that both the injured worker and the employer comply with their obligations under the Act. So employers must endeavour to try and find suitable employment for the worker whilst they're injured. So that often involves providing the injured worker with suitable on-night duties. And at the same time, the injured worker must make reasonable efforts to actively participate in their rehabilitation. So in other words, attend medical appointments and comply with reasonable requests to undertake light duties. So how do you make a workers' compensation claim? Well, the best way to make a claim is to do so online at www.worksafe.qld.gov.au. But you can also telephone Work Cover Queensland Direct. You do not need the employer's permission to make a workers' compensation claim. And workers' compensation claims are normally accompanied with a workers' medical certificate that you can have prepared by your treating GP. Now, in relation to timeframes, for a statutory work cover claim, you generally only have 6 months after the injury occurs or you become aware of the injury to lodge a claim. So it's important that you act in a timely manner and lodge the claim as soon as you become aware of your injury. For a common law claim, you generally have 3 years following the injury to lodge the notice of claim for damages. And as stated before, you're only able to pursue a common law claim once the statutory claim process has finished. So you have to have an accepted work cover claim in order to have a right to pursue common law claim. So what happens next after a workers' compensation claim has been lodged? Well, work cover then gathers information from yourself, the employer, GP and witnesses in order to make a decision whether or not the claim is accepted. As a general rule, work cover have 20 business days to decide whether to accept or deny the claim. In fairly straightforward cases where it just needs to be determined that the injured person was a worker and that they were injured at work, WorkCover will generally make a decision well within the 20 business days. But in more complex claims, delays do happen if WorkCover have difficulty getting information. So it's not uncommon in psychological claims for WorkCover to take rather longer to make a decision. If they are going to take more than 20 business days, WorkCover are obliged to tell the injured worker about the delay. So not all WorkCover claims are accepted. A number of reasons for rejections are as follows. WorkCover determined that your injury or illness is unrelated to your employment. As I've said, work has to be a significant contributing factor to the injury. So you have to be able to prove that the injury was caused by work. Sometimes the medical evidence will determine that the worker has not suffered a recognised injury. Alternatively, if the injury did not happen in Queensland or the worker does not have a connection with Queensland, then it will be rejected and potentially referred to one of the other workers' compensation schemes in Australia. Another common reason why some claims are rejected is that the person does not meet the definition of a worker under the workers' compensation legislation. Simply put, in order to be a worker, it's usually the case that when you're paid your wages, tax is deducted at source by your employer, and WorkCover used that ATO definition to define a worker in Queensland. So if you're an independent contractor or an Uber driver or someone who is self-employed, unfortunately, you're not covered by the workers' compensation legislation. Another very common reason in pure psychological claims why a claim may be rejected is that the reasonable management action exclusion applies. And finally, if there's a delay with reporting the injury, that also presents problems with a claim potentially being rejected. So a common situation might be a worker's injured at work but does not report it to the employer or does not attend the GP, and then 3 to 6 months later believes that ongoing symptoms are related to work. It's going to be very difficult to have the claim accepted if it's not reported in timely fashion. So what to do if WorkCover rejects your claim? Well, you do have rights. The first right is to submit a review application to the workers' compensation regulator. That must be done within 3 months of the date that you receive the decision to reject the claim. The workers' compensation regulator will then take further information from the injured worker and the employer, and will then make a decision as to whether they agree with WorkCover or disagree. And what may happen is that your claim may then be accepted. If the application for review to the workers' compensation regulator is unsuccessful, then you do have a further right of appeal to what is known as the Queensland Industrial Relations Commission. That, however, unfortunately, is a very lengthy and complex process that can take many months, even longer, in order to get an outcome. In these circumstances where you believe you have had a workers' compensation claim rejected and the reasons are incorrect, then you should seek legal advice. So when do I need a lawyer? I'm often asked the question, when should one consult a lawyer if they've had an injury at work? My advice tends to be you should seek legal advice at the earliest possible opportunity in order to protect your interests whilst you're going through the statutory claims process. But certainly, if your claim is rejected or if your claim is complex, and in all circumstances, if you have received an offer of compensation from WorkCover accompanied by a notice of assessment, it is essential that you seek legal advice as to whether or not that offer should be accepted. And I recommend that if you've been injured at work where you feel that the injury has been caused by the fault of the employer, then you should seek legal advice in relation to pursue a common law claim for damages. So in relation to common law claims, as I've said, these are only available to those who have been injured because of someone else's careless and negligence. In order to succeed in a common law claim for damages, we have to be able to show that the employer has failed in their duty to provide the worker with a safe place of work. Now, the duty of care is a very high bar that is imposed by the legislation. So if workers are made to lift weights that are unduly heavy, or you've been injured as a result of defective work equipment, or if there has been, for example, a hazard on the floor that someone had slipped on, these are all circumstances where a valid common law claim should be made. And the advantage of pursuing a common law claim for damages is that you're entitled to compensation for a number of different heads of damage. The first head of damage is for what is known as pain and suffering. So the court will award damages for the injury sustained as a result of the negligence of the employer. In addition to this, you're able to claim lost past wages as well as future loss of earnings if your injuries have prevented you from working or are going to have an impact on your future earning capacity. In addition, you're able to claim for past and future loss of superannuation benefits, which are not paid while someone is on work cover. And finally, you're able to claim expenses for both past and future medical treatment, which in some cases can be fairly extensive. In relation to time limits for a common law claim, you only have 3 years from the injury in which to lodge and have a compliant notice of claim for damages. So it's important that you seek legal advice in a timely manner. In relation to the common law process, this usually takes between 6 to 9 months from when the claim is lodged until you reach what is known as the compulsory conference stage. A large amount of matters are resolved at this compulsory conference stage, where both sides are encouraged to sit around the table and negotiate a settlement of the claim to achieve an acceptable monetary figure. So people often ask the question, well, how much is my claim worth? Well, that very much depends on the circumstances. It's certainly not one size fits all, and everybody's claim is different. What I can say is the purpose of the common law claims process is to try and put the injured person in the position they would have been in had it not been for the accident. Therefore, if you have been off work for a considerable period of time, or you're unlikely to be able to return to work, then the purpose of the process is to try and recover those lost wages for both past and into the future. You're also entitled to recover damages for medical expenses, and the factors that will have impact on ultimately what the claim is worth are things like the amount of time required of work, your age, and how many years you've got until retirement age. So that's why claims are worth different values. A 40-year-old with a significant back injury that's unlikely to return to work, the claim's going to be worth more than a 62-year-old with the same injury who's got less years left until the notional retirement age. I am pleased to say that these days the courts look at the notional retirement age of being approximately age 67. So these sort of claims we will seek to recover lost earnings up until that time. During the course of a common law claim, the other side will and have an entitlement to request and peruse your medical records. So pre-existing injuries, medical history, work history are all relevant to ultimately how much compensation the injured worker is entitled to receive. So some key points about the workers' compensation legislation in Queensland. In relation to a statutory claim, you don't have to prove fault. So as I've said, in order to receive WorkCover benefits and have WorkCover pay for reasonably necessary treatment, it's not necessary to prove that you were injured at work and it was someone else's fault, but rather simply that you were injured at work and that work was a significant contributing factor. Workers' compensation covers more than just lost wages. So WorkCover have an obligation to pay for reasonable necessary medical costs. So in some circumstances, it might be recommended that you have surgery to recover from your injuries. And if that is determined by the medical evidence, then WorkCover will pay for that surgery. Work cover will often pay for treatment such as physiotherapy, because the number one aim is to try and get the worker back to work. As I've said, work cover benefits don't cover all your wages. They only cover a percentage of wages. But if you were to pursue a common law claim, then the purpose of that process is to recover all your wages. It is possible to appeal a work cover decision to reject a claim. And I've spoken about the time limits and criteria in that regard. And just to recap again on the time limits for making a work cover and common law claim, you have 6 months from the date you were injured in which to put forward a statutory work covers claim, and you have up to 3 years from the time of the injury in which to pursue a common law claim. So just bringing this all to a head, some other common questions that were asked in this line of work. What do I do if my employer does not want to make a workers' compensation claim? Well, as I said, you don't need the employer's permission to pursue a claim. And in order to have reasonable and necessary medical treatment paid for and the wages covered whilst you're off work, then you should pursue a claim. All employees have to have insurance. So my advice is that if you require treatment and you need to be off work, then you should pursue your rights under the workers' compensation legislation. People often ask, can I get fired for making a workers' compensation claim? Well, the answer is no. There are rules in the employment legislation protecting against that. Are contractors entitled to workers' compensation? Well, unfortunately, not. You have to satisfy the definition of being an employee to be entitled to workers' compensation. But sometimes persons who think they're independent contractors actually satisfy the definition of being an employee. So if in doubt, seek legal advice as to your entitlements under the workers' compensation scheme. Again, people often ask, can I claim workers' compensation if I have a pre-existing injury? Well, the answer is yes. As I said before, workers' compensation also covers aggravations, and it's very common for people who in their career have always done heavy manual work to have a number of injuries to the same part of the body. As long as it can be established that some sort of injury, whether it be minor or aggravation, was caused by work, then you're entitled to make a claim for damages. And finally, what do I do if my employer doesn't have workers' compensation insurance? Well, that's not the injured worker's problem. That becomes a problem for the employer, who will suffer the consequences with WorkCover Queensland. But that doesn't preclude you from making a claim. So the claim is made against WorkCover, and they'll sort the insurance situation out with your employer. To read more about other common questions, please go to our website. And finally, I'll leave you with some more WorkCover resources that are on our website if you have any further questions regarding your WorkCover rights in Queensland. I'd like to thank you for listening. I wish you a good day.